Hello, everybody. It's great to be with you and thrilled that I get to do that 2 weeks in a row. It's a nice treat. Last week, while I was hosting, we had some technical hiccups. I apologize for those, but with any luck, all of you were able to follow along and roll with it. It's my understanding that everything that we worked through last week was recorded so that if you had any content that you missed or needed to go back and double check, that's available to you. Certainly, of course, reach out to me if there's anything that I can help navigate. But here we are on the 17th of September with more to cover and new presentations ahead. We're on the cusp of fall officially, although for many of us who have kids back at school and the like, it has felt like fall for some time. There is a really great cross-section of our firm represented in today's program. So if Kathy, you could go to the next slide, please, I'll explain what I mean. I'm speaking with you, of course, from New York City, as I usually do. And then next, Kamisha Parkins will be back on the program. She was a presenter last week, and she has a few clarifying points that she wanted to make relative to the workplace violence relating legislation that you talked about last week, and essentially some new information that we want to ensure all of you have. Mario Ayub is with us from our Buffalo office, and Mario has been on the program many times over. We're grateful to have him back. And Mario spends a lot of time working in the cybersecurity and data privacy spaces, in addition to some others where I've had the pleasure of working with him personally. And what Mario is going to be covering is a top level approach to how one navigates the use of AI in the workplace. After that, Kyle Ritchie, who is back with us from our office in Kansas. Yes, Kansas, for those of you tuning in. I remind you that we have a really highly regarded practice focused on athletics and higher education. Kyle is a part of that, and he will be talking about a major case that actually we've heard about from Paige Carey a few weeks ago, but there's been some important movement. It's House, and we look forward to hearing what Kyle has to say. Kyle, welcome back. Emily Fallon, also with us from Garden City, who has been on the program a few times over, will be talking about public records requests and some changes in how that will move forward relative to public officers in New York State. And then Allison Gavala is with us, a new part of the Bond family, recently joined us. Allison is going to be focusing on environmental law, which is where her practice is centered. And she'll be talking about recent developments involving forever chemicals, as they're more casually known. So with that, why don't we move to our first speaker, please, who is Kamisha Parkins. Kamisha, again, is with us from New York City. And Kamisha has a few updates concerning the Retail Worker Safety Act, as I noted, also pertaining to workplace violence. And it is now your time, Kamisha, to let us know what is it that got updated and what should we be paying attention to. Please go right ahead.
Thank you, Gabe, and thank you all for joining us this Tuesday. As Gabe mentioned, I do just have a few quick points of clarification, as there has been a chapter amendment to the Retail Worker Safety Act legislation that I previously discussed during last Tuesday's webinar, which was signed into law on September 5th of 2024 by Governor Kathy Hochul. And as some of you may recall, this new legislation imposes requirements which are intended to protect retail workers at a wide range of small to large-scale retailers in New York State from workplace violence. Now, my first clarifying point is that most of the law's provisions will go into effect in 270 days. That is June of 2025. There are a few other requirements included in the legislation that take effect later, which I did discuss at length last Tuesday, but I will also touch upon later today. Next slide, please, Kathy. So really quickly, I did want to address coverage under the Act just because since I discussed it in last week's webinar, many of you have reached out with questions concerning the Act's coverage, understandably so. The scope of this legislation is very, very broad. And at this time, we do expect that most questions related to the Act's coverage will be addressed when the Department of Labor releases a guidance document. And right now, all we know is that covered employers will need to have retail employees that work in a retail store that sells consumer commodities. So we expect that the Department of Labor will release guidance as to what exactly is encompassed in the consumer commodities requirement. Next slide, Kathy. So more clarifying points here with regards to the requirements in the legislation. As I discussed last week, employers who are covered under this act will need to implement a workplace violence prevention policy, which is expected to go into effect in June of 2025. Employers will also need to develop and implement a workplace violence prevention training program. And this training will need to go into effect also in June of 2025. Now, there are some specific requirements here for employers with at least 50 retail employees. They must begin this training to all retail employees upon hire and on an annual basis thereafter. There is a small nuance for employers covered under this act with fewer than 50 retail employees, and these specific employers must provide training to all retail employees upon hire and once every 2 years thereafter. So this training will have to take place either annually or biannually based on the number of employees that certain employers have. There is a requirement as well to have notices be provided at this training. And I did discuss that last week as well, but I did provide it here on this slide as well. And another point to clarify with regard to what was called panic buttons is now called silent response button that certain employees under this act will need to implement into their workplaces. And this only applies, I do want to make this note again, this only applies to employers with 500 or more retail employees, and it is effective January 1, 2027. Again, January 1 of 2027, and this is a statewide requirement. It is not a nationwide requirement. So New York State employees with 500 or more retail employees will need to provide access to a silent response button for retail employees. And this button will not be linked to law enforcement. I did report previously that it is. It is not linked to law enforcement. It is merely linked to request access or request assistance rather from a security officer, manager, or supervisor while the employee is working at the employee's location. Next slide, Kathy. So just some takeaways for you all. At this moment, there's no immediate action required. Bond will continue to provide further information about the applicability of this new legislation once guidance from the Department of Labor has been published to the website, which we expect to happen in the coming weeks. And also, I did want to let you all know that the Department of Labor will publish a model workplace prevention policy and a model workplace violence prevention training program that employers may adopt in their workplaces. Thank you.
Misha, thank you very much for taking the time to offer those clarifications. And there are a few questions in the chat, so if you wouldn't mind addressing those, I know that those audience members would appreciate hearing from you. And please come on back to the program when there is additional information as we get closer to implementation, including those DOL guidance documents that you indicated were likely soon forthcoming. In the meanwhile, though, let's turn to our next speaker, please, who's Mario Ayub. I mentioned that Mario is with us from Buffalo. He is a regular on our program, and we're grateful for his regular presentations. Today, Mario is going to be talking about acceptable use of AI in the workplace. We have presented on AI on this program a number of times over, and at this point, we're really looking to just hear what's next and what's new. Mario, the floor is yours.
Gabe, and to everyone for spending your lunch hour with us today. Yeah, we've talked in the past about some AI on the program, but wanted to drill down into what is often a company's first step into adopting AI technology and implementing it among its workforce is setting up guardrails for smart use of AI. Next slide, please. So I'm not going to spend too much time on the background information so we can get into the acceptable use discussion, but just for everyone's benefit here who are not necessarily familiar with the technology or haven't used it as often as some of us have, just a brief overview. I pulled out three definitions for artificial intelligence that I think are worth noting. Generally speaking, AI simulates human intelligence by leveraging large data sets, massive amounts of data, and computer processing power to make decisions and perform tasks. That's it at its most basic level. Machine learning is something we've all lived with for a long time at this point. If you shop on Amazon or any online storefront, you're getting those product recommendations based on your activity, based on the clicks. Same with media websites like Netflix or YouTube or Hulu. They're looking at very predictable use patterns from their users, so watch time or clicks, and will extrapolate off that data and recommend things for you to purchase or watch. That's kind of been around for a while. It's not very new. Deep learning is this next iteration of AI that's really taking center stage with ChatGPT and other types of generative AI, which I pulled out as a separate subsection here because it's kind of taken on a life of its own. But this is deep learning is a much more sophisticated AI tool. It doesn't require structured data or predictable inputs. So like with machine learning, the model is predicting clicks, the model is predicting times you viewed a page, things that it expects to see. Deep learning, you could insert pretty much any type of content in there, text, video, even audio recordings, anything unstructured. And the model is able to digest and make predictions based on that input. So Google photo search, if you put a photo into the Google search, it'll actually do a reverse web crawl for you and pull up results based on the photo. That's an example of some unstructured data that can be fed through the model and produce some usable results. And then, like I said, generative AI, a subset of deep learning, but worth pulling out because this is really where AI is starting to interface with our work environments and our productivity apps. So that's where we're going to spend most of our time today discussing. Next slide, please. So again, not going to spend too much time here, but learning patterns, making predictions, and then using those predictions to perform tasks. That is very, very high level what a lot of these AI tools are doing. That's kind of the underlying mechanics. Next slide, please. Main drivers of AI so far, why more companies are adopting it. Cloud computing is reducing the cost of storing data. As I said, AI requires a massive amount of data to be effective and to produce accurate results. So the fact that it's easier and easier and cheaper to store that data is really incentivizing innovation in this space. Same with mobile technology and social media. Mobile tech is allowing us to access these tools on the go. ChatGPT and Copilot, which our firm uses in a secure version, is readily accessible on your phone, and you can use it on the go. And then social media is providing another large source of data to train models on and really develop the technology further. And a few other things, but I want to get to the main points of our discussion here today. So next slide, please. So some tools that you've probably already worked with or seen out in the wild. A lot of companies are starting to incorporate ChatGPT into their workflows, whether this is for marketing materials or as an automated copy editor for drafting blog posts or some engagement type pieces and content. We also have Elon's Grok, which is on the platform X, formerly Twitter, that's really focused on computational exercises and extracting data from the platform itself. We're seeing a lot of marketing groups within smaller companies rely on things like DALL-E to generate banners and different templates for marketing materials in low-cost digital art. And then Google Gemini, other companies are using that in opposed to ChatGPT, who are more integrated in Google's system. It makes more sense for them to use Gemini in their workflow. And so these are some of the more basic generative AI tools, but then you're starting to see AI crop up in all sorts of other back-end HR platforms, payroll platforms, marketing, email management campaigns. AI is pretty much everywhere at this point. And there's a good chance your company is already using it. The question is your company concerned with how it is governing the use of it and how the software is subject to certain controls to make sure that your data is safe, to make sure your clients' and customers' data is also safe. Next slide, please. So some benefits of adopting this technology, some easy, more obvious points here is just efficiency and the ability to get some of these back-end tasks done quicker, prioritizing maybe time-consuming tasks. I've used AI in the back end of my workflow when I would like to synthesize larger documents and get main points extracted from them. Obviously, that does not take the place of actually reading through materials carefully. But if you're working on something and you just need to get started, understanding a concept, AI is very good at that. It can help with proofreading, formatting documents. It can build you a website. It can build you marketing materials, and we're starting to see it crop up pretty much everywhere in the corporate world. Next slide, please. So the importance of putting together an AI acceptable use policy and really starting there before implementing this technology is really highlighted by the risks, the very real risks that come from using this technology. Accuracy is a huge concern. We are often kind of trained to believe that this is a computer output. It's carefully crafted. We don't need to look at it. There have been many documented cases where AI programs have hallucinated, made up facts, misrepresented positions. It's a very dangerous road to go down when you're just trusting the output without really checking your facts. That's always an issue. Bias, which is kind of related, really more relates to the type of data that's being fed to the model. Maybe the model is reading the data accurately, but the data was collected with some sort of implicit or explicit bias that's going to affect the results, even if the model is functioning. Transparency, we're seeing this a lot in the regulatory context because we're having a lot of either new regulatory committees out here investigating proper use of AI and future law, or introduction of new law that's not yet into effect. This really emphasizing the need for companies to be able to explain how they use AI, how people's data interacts with the program, and to explain how the use of AI does not discriminate against certain classes or individuals, and how it does not affect consumer rights, privacy rights, things of that nature. So transparency is a large issue right now for many companies who are using these tools but don't really have an understanding on how they work. And then, of course, privacy and security is always a major concern. Do you have consent for the data that you are using in these models, or did you collect this data from another source and now want to repurpose it? That might run afoul of some laws, especially state consumer privacy laws. And then security: are you protecting your data? You need a lot of it for these models to run. Do you have safeguards in place? Next slide, please. So building an AI acceptable use policy. Now that we know what the risks are, the exercise here is to make sure you have all your key stakeholders in place. Everyone who's going to be using the AI tools in your company, from the lower level employees to the key decision makers, they should be involved in at least giving feedback on how this policy looks. So it has to be flexible enough for everyone to use. Provide guidance for the proper use of generative AI, include guidance on security, data integrity, who's responsible for the data. Set up a permission structure. If someone wants to use a tool that's not already approved by your company, who do they go to for approval? making sure that your employees are using secure means to access the tools. So a lot of companies, for instance, are not allowing their employees to access ChatGPT with the same type of credentials they would use for their work email. So if one gets compromised, then everything else becomes compromised. And then always encouraging checking that final work product, not taking the output from the AI model at face value and making sure it's accurate. Next slide, please. And Gabe, I know I'm running over a little, so I will wrap this up in a second. So here's some examples of what could be permitted uses and impermissible uses for your acceptable use policy. And they should be general enough to allow people to actually get something out of the tools, but clear enough where they know what areas to stay away from. So for general knowledge questions, if you're just brainstorming ideas for research or putting together a marketing campaign, you want some ideas, generative AI is very helpful in that regard. So brainstorming, organization, drafting formulas for Excel. This has really helped me because I don't have a very proficient background in Excel, but I needed it for a couple projects that I was working on. So ChatGPT and Copilot was able to help me build formulas that I wouldn't otherwise have been able to use. So that kind of levels the playing field for a lot of different computer programs. It helps you with coding and software design as well. Summarizing research, creating outlines, a lot of this back-end productivity stuff. We certainly welcome that type of use in a secure environment. And then in impermissible uses, you're starting to see a lot of the same themes. Using unedited, unanalyzed text created by AI, copying and pasting client or customer data into an AI chatbot. Once that information leaves your keyboard into the AI platform that's connected to the internet, there's no guarantee that data is going to be saved. So you want to encourage employees to really limit the amount of personal data, sensitive data, or eliminate that type of information from being entered into these programs. And then failing to cite an AI chatbot when used as a resource. We're seeing some local laws start to form where, depending on your industry, if you're using AI to generate work product or report, legal industry is starting to pick up on this as well. You need to disclose your use of AI. Next slide, please. So yeah, again, just to recap, everyone should be well keyed in on how it works. Training should come before any implementation of any AI tool. For when our firm implemented certain tools, we had a training for everyone. They had to sign off on the policy and understand it before they could use it. Outline ethical use, map it to any existing code of conduct that your company already has, and make sure it's in compliance with your existing IT policies, your security policies, your incident response policies. Make sure the policy works within the environment that you already have. Next slide, please. And then finally, when you're adding tools to this policy as your list of approved tools, make sure you're running through an evaluation checklist. Does the tool have necessary security documentation to make sure your data is safe? Does it work as intended? Demo the product. Does it align with either outside counsel's guidelines or outside clients' guidelines for the use of AI? And is it efficient? Is it worth the money spending on this tool? So there's just a couple of guidelines there for evaluating. And I think Gabe is here to tell me my time is up. So if you have any questions, please feel free to reach out to me now or after the presentation. I'll be happy to take your questions. Thanks.
Mario, thank you. Your time is up only because we have other presentations behind you, but you are always welcome back, especially as this topic continues to mature. There are a number of questions received in the chat, so if you wouldn't mind kindly attending to those, that would be great. And now let me introduce our next speaker, who's Kyle Ritchie. As I mentioned, he's with us from our Overland Park, Kansas office. Kyle has been on the program a couple of times before, and we're grateful for that. It gives all of you tuning in an opportunity to understand just how invested and sophisticated we are in the work of institutions of higher education and collegiate athletics. And Kyle is, among other things, a former professional golfer who has been working at Bond now for a number of years and is here to give us an update on House, which we heard about last month on the program, probably about 6 weeks ago at this point, and there's been some movement since. So he's going to set the stage and then tell you what's new. Kyle, welcome back, and thank you so much for taking this time.
Thanks, Gabe. And obviously I wasn't that good of a professional golfer because I am a lawyer now. So keep that in mind as I understanding my position here. As Gabe had mentioned, and as you may be aware, college athletics is certainly in the middle of a tempest, trying to understand the direction going forward. As you're aware from your presentation last month regarding the House case, that portion of name, image, and likeness and compensation being paid to student athletes is a large piece of what's being considered going forward. The effects of those decisions, whether there's a settlement and similar claims under antitrust statutes, are really trying to set the stage right now for what college athletics are going to look like here in the near future and then the long-term future. At a Division I all the way down through Division III and NAIA levels. Next slide. So I'm not going to cover this in detail. I just want to remind you what the House case is. It's a case against the NCAA, the Big Ten, the Pac-12, what's left of it, the SEC, the ACC, and the Big 12. A claim for student athletes beginning in June 2016, which was the statute of limitations date when it was filed. Sets forth the class, and it's for money that they should have received for commercial use of their NIL. Next slide. And as was likely discussed last month, there's a settlement agreement in place that was brought out early in the summer. Both plaintiffs, the NCAA and the relative conferences, signed off on it. The idea being a $2.78 billion payment to the plaintiff class, and then a compensation model going forward that is basically it's looked at as a 10-year model going forward with annual escalators and the ability to renegotiate on certain terms. The money's supposed to come from broadcast disbursements, other fundraising by an institution. The idea being that there's a cap between $20 to $22 million that schools can choose to use should they see fit for NIL compensation to their student athletes. Scholarships are considered in addition to that annual cap amount. There are some caveats within educational payments and added scholarships that may count towards that cap, but we don't need to dig into that necessarily. The big piece of the House settlement case, and this is what's really come up lately, is third-party NIL compensation. It's not included in the compensation cap. However, that third-party NIL compensation must be for a legitimate business purpose, and fair market value must attach to it. Now, as attorneys or as business people, we may ask what is fair market value and how are we going to determine that? And that's a good question. But the idea behind it is that there's an NIL clearinghouse that's run by a separate institution from the NCAA that collects contracts, collects data on these deals. So essentially we've got enough data to understand what fair market value for certain services conceivably would be. Next slide. And to finish this out, just what House doesn't address, we don't touch whether student athletes are employees. That's obviously a big issue for all of our institutions, really, that we represent, all the way from D1 to, I guess, through NAIA. The effects that a decision that they would be based upon, a decision that student athletes are employees, and the effect that may have on financial decisions and enrollment is certainly something to pay attention to, but it's not addressed here. The concept of amateurism, there's another case out there that, the idea is that you should be able to play for prize money, but then also be a student athlete and receive a scholarship. That's a case that's in its beginning stages. There are other antitrust cases against the NCAA that are not covered. The Fontenot case was filed recently. It's in its beginning stages, but so far the attorneys in-house have been unable to bring the Fontenot class in underneath the House umbrella. And Lastly, as it relates to the House settlement, we haven't seen the application of Title IX really considered either in the agreement or by the judge at this point in time under the settlement. So that remains an area to be certainly discussed and an area to try and be ready if and when House does settle. Next slide, please. So the main update that I want to give you is that on September 5th, 2024, the initial House preliminary settlement hearing took place. Judge Wilkin from the Northern District of California declined to grant pre-approval of the settlement agreement, depending on your position on the case settling. It was either she was supportive but had some concerns, or on the other side it was not supportive at all, and we've got to go back to the drawing board and start over. Obviously I think the truth is somewhere in the middle there. She expressed three big issues that call into doubt the settlement, three issues in particular. The first was the impact that there's limits on NIL opportunities in the NIL market. By putting those in place going forward under the settlement agreement, we've been in a situation really for the last 6 months since the NCAA became enjoined from enforcing specific NIL related rules, that it's been somewhat of a free market to the point where people could get paid really whatever they wanted. There's been negotiation going on. There haven't been any restraints. So it's from a certain position, it's hard to go back. And that is, I think, a piece that's really playing into these decisions. The second is obviously, I think you can understand that, the effect that a settlement like this may have on future class members, future student athletes. It's, to bind them to potential terms going forward is certainly something that is certainly considered very important from Judge Wilkins' standpoint. And like I said, I think that's pretty easily understood. The last piece has to do with the effect on collectives and third-party businesses who utilize student athletes for NIL related deals or pay student athletes for NIL related deals. As I talked earlier, there's a requirement of fair market value. There's also a requirement of a valid business purpose. And so if you look at what a collective essentially is in a lot of ways, it's been a vehicle to process donations to that business and transfer that money to a student athlete, in exchange for maybe it varies across the board, but it could be as much as just a couple social media posts, to the point where you've got tens or hundreds of thousands of dollars being transferred in exchange for, a couple of posts about a business that they don't really have a business, but other than supporting the student athletes at the institution. So that's a big hit. It's a big piece that the NCAA and the plaintiffs are trying to corral in the settlement agreement with the valid business purpose idea. The intention is not to prevent Caitlin Clark from being sponsored by Nike and Gatorade while she's playing at the University of Iowa and doing commercials and getting paid lots of money for it. That will pass the valid business purpose test when it gets a little cloudier. You will look at situations more like it's not really advancing a business purpose. It's not something that someone would normally pay, X number of dollars for as far as advertisement. That's where it gets called into question. So that piece there was some concern, I think, from Judge Wilkin, and I think she also looked at, again, how that impacts the amount of NIL money necessarily available for student athletes. So with that in mind, that's a piece that she has to clarify. She has to clarify, what a booster is and how it pertains to these payments. The NCAA continues to seek to eliminate payments for recruiting expenses. They want they want some sort of the model without the inducements in place, like it has been in the past, obviously updated with the revenue share and that sort of thing. So, as of now, the parties have been renegotiated. They've been back at the drawing board, trying to understand and clarify some of the rules, clarify the logic for some of the rules. And the idea is they're going to present at the next hearing, which is September 26th. The NCAA has also set forth a couple of positions. One of them being as it relates to the effect on collectives. If that is a piece that has to go away, and that that they're going to take that protection out of the settlement agreement, the NCAA has indicated that they may opt for trial, thus eliminating the settlement and really throwing collegiate athletics, into more of a, I don't want to say a tailspin, but certainly more into chaos, to the point where what comes next will kind of be a to be determined status as we move forward. And that's all I have for now, but stay tuned. It'll change next week, as most things in college sports are right now. So,
well, Kyle, thank you so much. And to your point about it changing by the minute, after that hearing on the 26th, I expect we'll know more. And please plan on coming on back to the program if you have the time. I know the audience would love to hear how this is all progressing. It's just so important in the world of collegiate athletics. But for now, let me turn to our next to last speaker, who is here from our Garden City office. That's Emily Fallon. She has been on the program a number of times before, and we're shifting gears in terms of topics, looking at Section 87 of the Public Officers Law, some interesting issues relating to public records requests that we thought were worth everyone's time. So, Emily, if you please highlight them. Thank you again for coming back onto the program. I look forward to learning with the audience.
Absolutely. Good afternoon, everyone. So by way of background, we're dealing with the Public Officers Law and FOIL. So FOIL, or the Freedom of Information Law, provides members of the public the ability to access government records in order to promote transparency and accountability within state and local government. So FOIL applies to municipalities, including cities, towns, villages, public school districts, which is something that's a hot topic on Long Island, and any other New York State governmental entities. So specifically, FOIL requires state agencies to do several things, including they have to enact rules and regulations governing the availability of records. They have to maintain certain records for periods of time as set forth within the Public Officers Law, and three, to make all records available for public inspection and copying, except in instances where information can be redacted, subject to certain exemptions. Next slide, please. So the first question when we're dealing with this type of instance is, what is a record? Subject to disclosure by FOIL. FOIL defines a record as any information kept, held, filed, produced, or reproduced with or for a state agency in any physical form whatsoever. So, as is relevant to the amendment that I want to talk about today, employee personnel files and disciplinary records are per se records under the statute and are therefore subject to production and disclosure under FOIL unless a certain exemption applies. So, practically speaking, this means that a member of the public can make a FOIL request to a public employer for an employee's disciplinary records, and they are entitled to receive those disciplinary records subject to the relevant redactions that may be available. The most common exemption for redactions when it comes to disciplinary records is there's a balancing test based upon protecting the privacy of that public employee versus the public's information in obtaining that information. And from there, it's a balancing test. So if the public employee's privacy does not outweigh the public's interest in learning that information, it's otherwise redacted. Next slide, please. So about 2 weeks ago on September 4th, Governor Hochul signed a new amendment to the Public Officers Law, which imposes an affirmative obligation on public employers to now notify an employee whose disciplinary records are the subject of a FOIL request, effective immediately. So that meaning if you've received a FOIL request looking for employee disciplinary records on or after September 4th, you must notify that employee that their records are being disclosed pursuant to FOIL. Specifically, the amendment requires the development of a new policy, which creates a notification procedure for when an employee's disciplinary records are requested through FOIL. The intent of this amendment is to promote recruitment and retention of public employees in the public sector, obviously, by recognizing that their professional dynamic is a little different than those within the private sector, because they're public servants, right? And it's just a different role. Next slide, please. So as I said, this amendment's very new, but one thing that jumped out to us in Garden City upon learning about the amendment is that it may be subject to bargaining if a public employer has employees which are otherwise covered by a union. So we anticipate that public employers may have to bargain with union employees over the amount of notice given to that public employee developed within that new policy. One thing that might get a little tricky that needs to be considered is that there's a statutory requirement which defines the time frame that a state agency has to respond to a FOIL request and produce the relevant records. So typically, a governmental agency has 5 days to acknowledge the receipt of a FOIL request in writing. So if a government entity receives a FOIL request, they have to respond to the person making the request within 5 days, kind of outlining, we understand what you're looking for. If not, can you please make it more clearly defined what you're looking for? And we expect that we will have these records to you by X date. And from that, the date of the acknowledgement letter, you have 20 days to produce the relevant records, unless there's an instance in which there's an extension, which is a topic for another day. But being that there is this statutory time frame within FOIL, that's something that needs to be considered when practically developing this policy in order to comply with the new amendment. And that's all I have as well for today.
Well, Emily, thank you very much for introducing this interesting shift. And as you noted, there are implications for public employers, which are a big part of the practice in Garden City, certainly as well for those requesting records too. So lots to watch here and to learn over time as this shift is implemented. But let's take a moment now and shift. We have one more speaker today, and one I expect you'll all be really interested to hear from. It is Allison Gabala. Allison is new to our firm, but certainly not new to the law. She's been practicing environmental law for a number of years now, sits in our New York City and Newark offices, and is interested in talking about something practical that all of us have heard about or otherwise even had concerns about. These are forever chemicals. It's a complicated issue, and there's some updates that are relevant to the law around them that Allison thought would be worth your time. So Allison, welcome very much to Bond, to this program, and we're delighted to hear from you. The floor is yours.
Thank you. And hello, everyone. Good morning or good afternoon. So I'm going to try and get through this without sounding like the boogeyman in the closet trying to scare everyone, because hearing the words forever chemicals doesn't exactly leave the greatest taste in anyone's mouth. But there is a reason we spend so much time talking about them. And there is a reason that we are concerned. And that's something you need to be paying attention to, both as a citizen, as a person living in your home, as someone who operates as part of a business. Maybe you're manufacturing something, you use products in your business. It is such a widely prevalent chemical compound that PFAS touches on everything. So if we could, the first slide, please. Without jumping too far ahead, I'm just going to take a moment to try and hopefully explain what forever chemicals are, or what PFAS is, without sounding too much like a high school chemistry teacher. So PFAS, which is the broad overarching umbrella that we use to classify all of these other PFAS substances, thousands of them, are what are commonly known as forever chemicals. And they're known as forever chemicals because once they're in the environment, they break down very slowly. They are treated much differently than other contaminants we are used to dealing with. Anyone who's ever purchased a home or rented an apartment has probably seen the lead paint disclosure that you're required to receive from the government that tells you if your house is over so many years old, you may or may not have lead paint. You should need the lead paint. Don't need lead paint. But lead is something that we know how it operates. When it gets into the environment, it's heavy. So if it's in soil or in water, it doesn't tend to travel very far from where its origin point was. PFAS, or forever chemicals, were designed to be something that was slippery. That was their initial purpose. They're found in so many products because they're incredibly good at just that. Their job is to be slippery. So you find them in wrappers for candies or wrappers for fast food, or in your raincoat, or on Teflon pans, or in makeup, firefighting things that you don't necessarily want to have stick to other things, which is part of what makes them so complicated. How do you catch something that was designed not to be sticky? If you think of, your kid's fish tank, you probably have a little filter in your kid's fish tank that's designed to catch all the waste, and it runs the water through, it catches it in the filter, and then once a month throw the filter out. That is hypothetically how we would deal with all chemicals that end up in the water. We run it through a much more sophisticated version of the filter than you find in a fish tank, but run it through that filter, clean out what you need to clean out, and return clean water back. But how do you catch something that was designed to slip through the filters, that was designed not to stick to anything else? So PFAS is something that affects everyone because not only is it found in a wide array of products across multiple industries, but once you do find it, there's a question of, okay, now what? I found it. I know it's probably not healthy for me. And I say probably because there are so many different compounds and this research is still evolving. So from what we know now, it's not great for your health. We need more science to say anything totally conclusively, but generally speaking, the consensus is you don't want to be exposed to any more PFAS compounds than necessary. They're not good for your health. They can lead to cancer. They can lead to an array of other diseases. It's not something you necessarily want in your home, in your food, or part of your morning routine. Yet it's somehow in eye makeup, nail polish, your shampoo. So you could have experienced it 10 times in the time between waking up and getting out of your shower this morning. So it is everywhere. You can't avoid it. It's hard to catch once you find it. And then once you do have it and have it collected, how do you dispose of something that is around for forever? So given all of these questions is why PFAS and forever chemicals are such an intriguing component of environmental law and something that everyone should be concerned about. Next slide, please. So as I was saying, the science and law around this topic is evolving, and it is evolving day to day, week to week, month to month. Right now, there are certain federal requirements for drinking water that have been around for a little bit. Those are listed on the left side of the chart in front of you. And they're only listed for certain PFAS compounds. As I said, there are thousands of compounds. So far, only some of them are regulated, and some of them are only regulated to levels of things such as 10 parts per trillion or 4 parts per trillion. Those are the enforceable drinking water standards. And then there are goals of things like 0. One of the questions that's currently at contention amongst scientists and industry alike is, how do you test for those levels? How do you get a test that will read something that is that tiny of a unit? Parts per trillion is a very, very small value to test for, especially with a chemical that we are not accustomed to looking for. So that is one of the additional challenges, is actually finding these things. But there are standards for drinking water. So if you are like me and are a concerned citizen separate and apart from your business interests, one thing you can do now is talk to your local municipality. Ask them if they have sampled your drinking water, if you're getting it from your municipality, and what the levels of PFAS are in your drinking water. There are programs out there for communities, for towns, for municipalities to be able to install remediation technology so that they can reduce the amount of PFAS in your drinking water. But before any of that gets put into place, first you need to know if it is an issue that your community is dealing with. Other federal requirements that currently exist, 2 of these listed substances are identified as hazardous substances under CERCLA, or the Superfund Act, which means that when there are federal cleanups of Superfund sites, you could also be required to clean up some of these PFAS compounds. Next slide, please. There are also currently certain state requirements. These, what I have listed here, are the New York proposed soil cleanup standards that would apply to all New York remediation programs, and these are proposed. They have not been finalized yet. But one thing I want to point out that I think is important to note is if you look at the units here, these are in parts per million. On a federal level, we were talking in parts per trillion. So that's a difference of 6 zeros between those 2 standards. So it shows exactly how much this is evolving as we in real time, because this science is new. Our knowledge of these chemicals is new. So as we're learning not only how to test for them and how to treat them and what their health impacts are, we're also learning what levels are and are not safe. So there can be a vast difference between what you're required to do on a state level and a federal level. So it's important to pay attention to not only what the federal requirements may be, but also what your state's particular requirements may be, all of which are changing. Next slide, please. So, looking forward, what to do other than to panic by the fact that this is everywhere. Please do not panic. That is not what we need to do now. But what you can do is, if you were acting as a citizen, talk to your local government about whether or not it's in your water. Reach out to those representatives, see if it's something your area is addressing and how they're addressing it. If you're looking as part of a business, go through your records and see if in the past you have used any PFAS compounds, because if you had used them previously, you still could be liable for cleaning them up now, especially as more and more of them become regulated in more and more environmental media. They're going to become part of the permitting process for a number of permits going forward. So knowing to the extent that you do use them now and preparing for either how to eliminate them from your operations or how to mitigate their impact in terms of their release into the environment is something you want to be doing now before all of these regulations are in place and not after the fact when you're going to be playing catch up. There's also going to be a lot of additional litigation. Right now, litigation about PFAS has been limited due to the limited science and the evolving regulatory landscape. But as more and more compounds are regulated and more PFAS compounds are regulated under different laws, such as under the Clean Air Act, which there has currently been a proposition to do, this litigation will become more regular and more frequent part of entities' existence. So knowing whether or not this may be something you may be dealing with in the future, because you historically used PFAS compounds, or you may currently be using them and want to try and remove them from your product line, now is the time to do that, as opposed to once all of these rules and regulations are in place, which could leave you in a part where you don't have what you need to operate your business or to feel safe in your home. So without trying to sound too scary, PFAS is there, more litigation is coming, more regulations are coming, and now is the time to act. And if you have any questions, please feel free to reach out to me.
Allison, thank you so much. It was very helpful to hear about this. And as Allison suggested at the end of her comments, she's available, having joined our firm earlier this summer. And we're really delighted to have the background in environmental law that she brings to our team. With it noted that we are a little bit over time, let me quickly, if Kathy wouldn't mind, tell you about upcoming presentations. I mentioned these last week, but I remind you about them. We have a series of programs around the state, same agenda, just different locations. The pregnant worker, what to expect when an employee is expecting. It's our labor and employment law fall briefing for 2024. Please do sign up for the briefing that's nearest you. And if for any reason you have issues with that sign up, you can reach out to me or to Kathy and we'll see what we can do to get it sorted. I won't be with you next week because Chris and I are returning to our regular cycle where we alternate weeks. But I will be with you on October 1st, and I look very much forward to that. So in the meanwhile, have a good transition formally into fall. And otherwise, thank you so much for taking the time to tune in. We appreciate your loyalty as always.